Hi everyone, and thank you for coming to today's webinar with my partner Rob Sedegakor from Stratco Property Solutions. Today we have Noah Levinson from Butnick and Levinson LLP, and today we'll be discussing the proposed rent laws changes. That's at this point I'll hand over to you, Noah. Thank you for joining us today.
Sure, thank you for having me. So the proposed legislation it was submitted June 7th, 2021. It has to do with changing the rights of property owners to charge a first rent when they create new borders to an apartment, and to change the rules of how you obtain substantial rehabilitation. First rents is generally when you combine two or more apartments, or you change the borders, reconfigure plus obliterate the perimeters of the apartment, which allows a landlord to disregard the prior rent history and then charge a market rent. Substantial rehab is when you gut renovate an entire building under a DHCR policy. It's called Operational Bulletin 95-2, in which you can deregulate an entire building from the rent stabilization framework. So under first rents, what the proposed legislation is it eliminates the landlord's ability to disregard a prior rent history to charge a market rent. This is done in three ways. One way is when you combine two apartments. The proposed law is that the new combined unit cannot be more than the prior two rents together. So if you have apartment one being $500 and apartment two being $500, you can't charge more than $1,000 for the new apartment 1-2. The other rule that's proposed is when you reduce an apartment and you make another one bigger, the reduced apartment the rent is decreased, the rent is lowered by a percentage, and based on the square footage of the decrease. And the larger apartment, you can't increase the rent. So in any instance, you're not allowed to increase the rent for a larger apartment. And the way this is very important is because landlords were looking to add value to buildings by disregarding a rent history by creating new borders. So if they took two railroad size apartments and they made it two boxes, or they made it a duplex, they could disregard the under market rent stabilized rent. But now the proposed law would take this away. It's a loophole that survived the 2019 rent laws, but it looks like it might not survive when the session comes back in 2022. The next proposal has to do with sub-rehab, which makes drastic changes to deregulating a building. The proposal involves you're required to apply to DHCR for an order to deregulate. Previously, as it stands now, if you sub-rehab a building, you're not required to apply to DHCR. You can just do the work, and then if you ever get challenged, you'll have your evidence. But now by requiring DHCR for approval, you're going to be subject to DHCR procedures, and you might create a problem where tenants weren't previously challenging a fair market building. Now they have a right to challenge it. Another thing that it does is it changes that the building cannot be, it has to be seriously deteriorated. Previously, it could be substandard or deteriorated. Here it has to be seriously deteriorated, which I think is a higher standard. And lastly, the thing that it does is that the owner can't be the cause of the deterioration. So if you have a building that has a lot of housing maintenance code violations and it's deteriorated, the owner can't be the reason for it. Now, unless your building is at the shores when Sandy hit, I don't know how an owner is not the reason why a building fell in deterioration. Usually these violations happen because there's repairs that are not being made. So it makes it that much harder to obtain a substantial rehab. There's other requirements, such as an owner is not allowed to right now you can't secure a vacancy by harassing a tenant. The current rule is that the new rule is that there's a 5-year investigation into harassment claims, so that substantial rehab applications are now going to turn into certificates of no harassment applications, in a sense, where they can get old tenants out of the woodwork to see if they've been harassed. Sorry?
Oh, sorry, I was going to jump in the question when you're ready.
Sure.
Yeah, so you mentioned obviously post the laws of 2019, one of the only ways to create value was to combine the units to set new first rent. For them, for my clients that have done this, what is the new strategy in terms of what's going to happen to the investors that had that business plan? When would this proposed new legislation be implemented, etc.?
So I think if the apartment's already been rented and you already have a lease in effect before this law gets voted on, you should be in the clear. I don't see how they could apply this retroactively. There's case law called Regina Metro that says you can't apply the 2019 rent laws to overcharges that occurred previously. And there's also case law on when they amended charging first rents previously to apartments that were temporarily exempt for 4 years, that you couldn't apply that retroactively to apartments already rented. So if it's already rented, I think you're in the clear. The problem is if you're doing the construction now and it's not going to be ready until after the law passes, I think there's a major issue. So the advice that I would give to all my clients is that you have to do the renovation and get it rented to a paying tenant as quickly as possible.
Okay, thanks. Yeah, so it sounds like this legislation is continuing the theme of disincentivizing landlords to invest in their buildings. You know, this new law isn't accommodating the costs of combining a unit. So I don't see why anyone would do that now. And this sort of goes in line with the fact that the buyers I'm seeing in the market are taking a long-term view with the hope that the political pendulum swings in many years to come.
There's no reason. Sorry, go on.
I was just going to say, what are your thoughts, Rob? What are you seeing?
So there's two things that I see happening here. If you know, a lot of guys that were involved in the old tenement building repositioning strategy that were buying, 6 to 10 unit vacant buildings and doing a substantial rehab. One, they're not going to be able to raise the rents given the unit configuration of proposed law that you have. And second, the delays on getting these approvals, it's going to increase their carrying costs and basis in the building. So frankly, buying those vacant buildings it's going to become more of a nuisance than a value proposition. Yeah. Second, putting investment dollars back into these buildings is also not that it was favorable to begin with. Now it's just the nail in the coffin.
Yeah, great.
So to elaborate on the substantial rehabs, Noah, so what we're seeing here is that it's open. So do all buildings, if you want to file for a substantial rehab, you automatically have to file for a certificate of non-harassment?
No, I was just using that as an example. So the certificate of no harassment is when you apply to HPD and they open up a 5-year investigation, whether you harassed any tenants. The proposed legislation on sub rehab says that you can't have harassed tenants in the last 5 years. So I think that would mean that there is going to, DHCR is allowed to investigate whether any tenants have been harassed. And harassment under the Housing Maintenance Code is very, very broad. It's basically any conduct that could be presumed to cause a tenant to vacate, even if a tenant doesn't vacate. So for example, if you have a lot of violations that you haven't fixed on time for a variety of reasons, it's presumed to be harassment. So that would work against the landlord that's working to renovate these buildings.
So here's a question. You buy an 8-unit building and it's vacant and all the rents are on average $500 a month. You want to file for substantial rehab. Can you reconfigure the units, or you can't do it based off of that first proposal that you had?
So if the law passes, then reconfiguring the apartments would be useless because you're not going to be able to raise the rent by charging a first rent. The building is seriously deteriorated, it's not because the prior owner failed to fix it, which that's a very difficult standard to meet.
So you can still reset the rents, but it's a lot more steps than you would normally have to take in order to prove it.
Sure, if you do sub rehab, it's not even resetting the rents. it's removing the building from the rent stabilization framework.
Right. I frankly, I don't know why someone would want to put more dollars into this this asset class right now.
It's not a friendly environment.
So if you can educate us on time frame.
Yeah,
Where,
please.
So the law was proposed in June. I think they're out of session until January. I think the earliest it's going to be voted on is in January. And then once it goes into effect, I assume it's going to be challenged based on the retroactivity that the law seeks, because the way it's written is it applies to buildings that have already been sub-rehabbed where an order hasn't been found. So I think you're going to have a retroactive argument against that. And you're looking at probably sometime in January when it's voted on.
Okay, great. Well, that wraps up today's session. Maybe we'll have to have you back in January, Noah, when there's sort of an update and get more clarity on proposed legislation. Our contact information is being shared now, should you want us to share the slideshow we've just shown you. And thanks for joining today. Speak soon.